represented by their lawyers. It is a force to be recognized so that Mr. Kieu Samphan shall not be released on bail. In my view, this is a premeditated view on their part, because one see one thing differently. One see it as a metal from one side, and I see it as a wood from my aspect. And I believed that Your Honors, as well as the co-prosecutors, to have justice, to seek justice. And if Mr. Kieu Samphan is released on bail, and if he were to exert pressures, I would like to see such evidence. If such evidence cannot be shown, please don't use this pretext. Secondly, they said if Kieu Samphan is released on bail, he may threaten and disturb public order. To cause social instability. And the co-prosecutors also showed the evidence of the 4th December event, that the victims reactions. So if he were to be released on bail, it could cause social disorder, it could threaten the public order. To that point, I would like to respond. Currently, everybody, including Your Honor, there is no such event as happened in the previously. There was a misunderstanding at that time, and I know that the victims' lawyers, as well as the victims, including myself, I am not disgratitude to my parents. A lot of my siblings and family members died. And why should I defend him? I would respect to the souls of those who died, including my father. I only want to seek the truth. Nobody is going to apologize to anybody until we find the truth. We have to consider the fact. But at the moment, even the royal government of Cambodia might say about the social or economical disorder with a bit of robberies or that sort of mishaps happened. This is not the factors that could cause to the release of my client. Now the point I would like to raise is that if he is to be released on bail, he would have his own safety risk. That is, he might be threatened because of anger. But during the 10 years in Thailand, nobody ever go and scold him or to strike against him like the strikes or the demonstrations against the land issue at this moment. The international co-prosecutor also went to the Thailand area to visit the area to ask for the people to complain against my client, Mr. Kieu Samphan. But they did not receive much. The situation is calm, is stable. But I respect their anger, but do not turn their anger into revenge. Because everybody acknowledged there was a killing during that era. And he himself is not afraid of death, of being killed. And don't take the events in 91 as a pretext, because there was a political motivation. And he has gone through a lot of such events even during the colonial regime. He was imprisoned once during that era. And I would like Your Honors to consider, if you think you like him and if he is to release on bail, he would have his own safety risk, I can tell you that he's not going to flee. The reason that he is released on bail so that he could grow vegetables or do a bit of gardening for his own use. And another point I would like to raise regarding his detention. I would like to modify the detention into the release under judicial supervision instead. As in the report read by the judge, there is no evidence showing the risk or lack of it. Because I have shown the evidence that I have, but you do not consider it. You are the one who detained him, then you have to show me the evidence if there is any risk involved if he is released on bail, because during the 10 years he lived, he has never threatened anybody or he has never been threatened by anyone. And now I do not know what to tell you, but I would like you all to consider it. Because detention is a serious form and he cannot gain back his honor by being detained, even if in exchange for money he lost his freedom, he lost his honor. And once again, with your honor's leave, I would like the chamber to consider to have my client, Mr. Kieu Samphan, released on bail under judicial supervision. And I would like to hear the observations by the co-prosecutors. If until today there is no change in circumstance, as I said, from the 2001 to the 2009, in that event he was beaten. And my students told me that, students went to beat Kieu Samphan, but they did not even know the face of Kieu Samphan. But that was the past. Now here is new. The situation is different. Like it said, for those who corrupt, who created bad things, they still receive impunity. But I want to counter that. I want to find justice, to seek justice. And I would like, I have shown the histories from the 91 until 2009 here. There is no risk on him. And if he is to go out and he is to be slashed to death, then nobody wants to go out. But this is non-existent. So from my point, I can say it's a wood, and from another perspective, they say it's a metal. So I would like to hear the observations by both the national and international co-prosecutor if the material change in circumstance really exists. And if he is to release on bail under judicial supervision, he can make a report on a regular basis to the police. That is my submission, Your Honor. Thank you. The President. The International Defense Council may make your submission.
Monsieur
My friend, Mr. Samphan, has spoken on behalf of the defense. The defense has a joint position. So Mr. Samphan has said what I think, and I do not feel that there is any need for me to repeat what he has already said.
The President, the co-prosecutor, please, the floor is yours. The prosecution Your Honors, in the name of the ECCC prosecution, I submit to uphold the response of the co-prosecutors against the appeal by the defense lawyers of Kieu Samphan, and I would like to make additional observations as follows. The co-prosecutor submitted the introductory submission on 18th July 2007, in which it set out the facts and the names of the charged person Kieu Samphan and the other 4 charged persons to be responsible for crimes committed under the jurisdiction of the ECCC. The charged person was provisionally detained on 19th November 2007 by the order of the CIJ for a period not exceeding 1 year and was charged with crimes against humanity and grave breaches of the Geneva Convention as defined in Article 5, 6, 29 new and 39 new of the ECCC law. A request for release on bail was initially made by the defense lawyers on 13th June 2008, which was subsequently rejected by an order of the CIJ dated 23rd June 2008. Notification of an appeal was submitted by the defense lawyers on 30 June 2008. However, the appeal was subsequently rejected. The defense lawyers made an appeal before the PTC on 22nd July 2008 against an order on the right and obligation of parties concerning translation. A public hearing was held on 4th December 2008. Subsequently, on 21st February 2009, the pretrial chamber issued an order dismissing that appeal. On 8 October 2008, the defense lawyers withdrew their appeal against the order for provisional detention and made an urgent request for release to the co-investigating judges. On the 28th October 2008, the co-investigating judges rejected that defense lawyers' request for release. For this reason, an appeal was submitted by the defense lawyers to the pretrial chamber on the 27th November 2008. The pretrial chamber set a date for the hearing on 27th February 2009 in respect to that appeal against the order refusing release of the charged person Kieu Samphan. However, 1 day before the hearing, that is, the 26th February 2009, the defense lawyers notified that they requested an hour delay in the hearing due to the delay of the international co-defense lawyer. Subsequently, on the hearing day, the national co-defense lawyer requested an adjournment of the hearing due to the international co-defense lawyer's absence. Hence, the pretrial chamber set a new date for hearing, which is today. In their appeal, the co-defense lawyers submit that their client shall be released on the following grounds. This co-investigating judge's decision contains an error of law in omitting to take into account the overall circumstances of the case for their justification, and their decision relies on the gravity of the alleged crimes. The co-investigating judge's decision involves an error of fact, as it does not present any evidence to support their assertion that risk can occur, exerting pressures on victims and witnesses, on public order, and on personal security. Releasing the charged person is the only appropriate measure. The charged person has been detained for more than 1 year, and due diligence is not shown in the conduct of the proceedings. In this matter, the prosecution submits that in their request for release on bail, the charged person has the burden to provide evidence showing that all factors justifying conditions for provisional detention are no longer satisfied. Within the context of the appeal, the defense lawyers need to establish material elements as justification for the charged person's release. Guidance principles may be sought from the international criminal law, especially in the case file of the ACSL dated 23rd February 2004, which states that in most of the jurisprudence in the ICTY and the ICTR, in the process of evaluating the arguments of the two parties, the burden in providing evidence still falls on the defense lawyers and not on the prosecution. In the practice of the international criminal law, once a suspect has been provisionally detained, the defense lawyers bear the burden in finding evidence to satisfy the court's condition justifying release on bail. The defense lawyers neither indicate evidence nor material changes in circumstance to justify the charged person's release on bail, nor any change in the conditions for detention. Therefore, on the 28th October 2008, the co-investigating judges refused the charged person's bail, and the duration of the charged person's detention is not excessive. In the co-investigating judge's order refusing release, it indicates that there are at least 12 witnesses' statements confirming the facts and are consistent on the knowledge and participation of the charged person in the alleged crimes. In the name of the President of the State Presidium, as leader in the Politburo of the Central Party, Office 870, and full rights member of the Central Committee of the Communist Party of Cambodia. Therefore, the co-defense lawyer's submission in this matter is untenable. On the submission that the order refusing release contains insufficient reasons, the prosecution submits that the order refusing release contains sufficient and appropriate reasons. As the co-investigating judges outlined the legal and factual arguments before issuing the extension order for provisional detention, they are not obligated to express their view on any or all other factors. Referencing recognized international jurisprudence, the pre-trial chamber finds that all court decisions, including those of the co-investigating judges, must provide reasons in compliance with international standards. The pre-trial chamber specifies that an obligation to provide reasons is required for the co-investigating judges to indicate the facts and the law that they consider before issuing decisions. The co-investigating judges discharged this obligation by making reference to the case file in general circumstances and in other circumstances, as they are not obligated to provide their views on all other factors. As in paragraphs 64 to 66 of the order on the appeal against provisional detention of the charged person in Sari, the pre-trial chamber indicates not obligated to provide their views on all other factors. The co-investigating judges have discharged their obligation in providing the facts and the law that they considered before issuing the decision. The ground stated in their numerous briefs form various measures for the delay which violates the rights of the charged persons for expeditious trial. Moreover, extension of provisional detention is appropriate for the following reasons: the gravity of the alleged crimes, the complexity of the case filed, the extent of ongoing investigation being carried out by the co-investigating judges. The charged person is faced with several charges in relation to the mode of liability of the joint criminal enterprise, of its extended and systematic character, and such provisional detention is warranted under the internal rules. Therefore, the submission that the decision contains insufficient reasons cannot be accepted. Regarding the issue of due diligence, the duration of provisional detention is not without any reason, and due diligence is shown in the conduct of the proceedings by the co-investigating judges. In general, specific investigation conditions within the ECCC jurisdiction shall be thoroughly examined. The charged person is charged with crimes against humanity and grave breaches of the Geneva Convention. The charged person is being investigated for planning, instigating, ordering, committing, aiding and abetting, and superior responsibility for several. In addition, as stated in the introductory submission and in subsequent documents on the charge of commissioning, indicating the charged person's participation in the joint criminal enterprise as a co-perpetrator for the crimes committed throughout Cambodia and within the temporal jurisdiction of this chamber. These crimes are the most serious and complicated, and if convicted, the charged person could face life imprisonment. By reviewing the case file, it clearly shows the progress of investigation and the additional evidence collected indicating the charged person's responsibility for the alleged crimes. In the order refusing release, the co-investigating judges considered that the passage of time shall be a factor to determine whether grounds for provisional detention are still being satisfied. Other international tribunals consider this time period as a relevant factor in determining the legality for detention. The defense lawyers fail to show that their client's detention for the past period of 1 year has any impact on fair trial. The ICTR has yet to find provisional detention inappropriate. The ICTY considers a longer period of detention is appropriate due to the serious nature of the alleged crimes. Moreover, the ECCC internal rules safeguard a measure for provisional detention as it can only be extended for a maximum of 3 years. In the current case file, there are well-founded reasons to believe that the charged person may have committed crimes which are being investigated. The co-investigating judges also note that since the arrest of the charged person, the investigation has progressed and a number of documentary evidence has been collected, and the passage of time has already been considered. Therefore, well-founded reasons to believe have strengthened from 1 year to another as the inculpatory evidence against the charged person has increased both in volume and gravity. In addition, the co-investigating judges have issued several rogatory letters for case file 002. The co-investigating judges themselves, as well as their investigators, have interviewed more than 200 witnesses in connection to the charged person and the alleged crimes. Moreover, documents in case file 001, which relate to the charged person Kieu Samphan, have already been transferred to case file 002. At the same time, the Office of the Co-Prosecutors makes contribution to the investigation by placing numerous documents since the submission of the introductory submission and after the arrest of the charged person. The evidence collected by the co-investigating judges, as well as the evidence placed in the case file at the request of the co-prosecutors, covers all forms and modes of the charged person's participation in the alleged crimes against humanity, including crime-based evidence, evidence which links the locations to the leadership structure in which the charged person exercised his authority in ordering, evidence to support his participation in the joint criminal enterprise, evidence to support jurisdictional elements, including widespread and systematic attack against civilian population. Therefore, the co-investigating judges discharged their duties with due diligence in conducting their investigations. Your Honors, the issue raised by the defense counsel that their client lived happily for 10 years at the border in the Pylon area. This is contradictory to what happened at that time. In 1991, Mr. Kieu Samphan entered Phnom Penh and was surrounded by massive number of population, so it is very hard to predict at the time. A huge number of population surrounded him, throwing rock at him, and only with the intervention of the government that Kieu Samphan could be escaped. And recently, everybody knows Kieu Samphan is being detained at the ECCC, and if he is to be released on bail, the victims, the families of the victims in massive number would show their anger toward Kieu Samphan and would have an impact on his personal security. In the name of the prosecution, I would provide the floor to my colleagues to continue our submission. Thank you. The President, the Chamber will adjourn for 15 minutes break. The graphic, all rise.